So I'll begin with Jim McGuire from Thomas & LeCicero, Deanna Schulman, and Monica Leal from the Miami Herald. And if each of you could introduce yourselves and tell us a little bit about what you do.
Sure, thanks, Anna Clara. My name is Jim McGuire. I'm an attorney, a partner with Thomas & LeCicero, the firm that Anna Clara just mentioned. And I won't go into too much detail about what we do, except to say that primarily we work with and protect content providers. Whether you're a journalist, a blogger, a publisher, an author, the TV station, we work with content providers. We help to protect their content. If they get sued for defamation or invasion of privacy or those sorts of things, we help trademark their brand names. We help copyright their content. And so we're on the side of making sure that you can speak and that your speech is protected. And that's a big part of my practice as well. And this is Deanna Schulman, who's one of my partners.
Hello, I'm Deanna Schulman. I'm also a partner at Thomas & LeCicero. I'm in our West Palm office, or Lake Worth, depending on whether you look at the address or where we're actually sitting. But I too work with content providers. A lot of my clients are individual bloggers. I have larger media organizations too that I and our firm represent. We also represent a lot of Spanish language content providers and other language content providers. So basically in Florida, we are one of the go-to places for content management for publishers like all of you guys, and it's free legal services today. It doesn't happen often, so please bring your questions because you don't get a chance to talk to lawyers for free and other people who work in the content industry, so definitely come prepared with your questions. We're happy to answer them.
Your bills will arrive next week.
Monica.
Hello, my name is Monica Leal. I am the Information Services Director at the Miami Herald, aka librarian. I am charged with managing the content lifecycle of everything, our stories, photos, multimedia. A big part of that is developing standards for copyright metadata in order to be able to reuse and process our content in a way that's legal and not a liability. So we'll be talking a little bit about that today, and make sure you have a lot of questions for these guys. It's not easy to come by.
So our presentation today is posed in 11 legal myths. Things that maybe some beginners or novice bloggers might believe, and just anyone who hasn't had the opportunity yet to familiarize themselves with the law of content creation and online media. So we'll start with our first legal myth. I don't need to trademark my brand.
Okay. By show of hands in the room, how many of you have trademarked your brand? Okay, a few. How many of you think you don't have to do that? Or how many of you think you can't afford to do that where you are in your business? Okay, that's a common impediment. People call us all the time. They're just starting their business and they say, well, I can't afford to trademark my brand. Actually, registering a trademark is a very cost-fixed process because it's driven a lot by the Patent and Trademark Office, but it is worth every penny you invest in doing it for a couple of reasons. One is, if you don't trademark your brand, you could come up with some wonderful, innovative way to express something, spend 5 or 6 years developing that, only to find out, worst case scenario, that somebody was doing it before you and you didn't know it. So now you're the infringer. So you've invested 5 or 6 years in building a business that you'll have to essentially change. You have to change your identity because it was somebody else's identity and you didn't know it. The other thing is, if you don't capitalize on your brand, you can't, or if you don't ensure that you're protecting your brand, you can't capitalize on it. You can't license it. You can't police it and enforce those rights that you might have in your brand. So it's a really important early step in the process. If you begin to come up with an identity for your business, you want to make sure that you go ahead and protect that identity so that you can protect other people from using it, and also so you can make sure you're not the one using somebody else's brand. So definitely, if you're on the fence about it, it's worth every penny you could invest in doing it. If you've already done it, you're a step ahead.
And one follow-up on that, if you happen to be in a position somewhere down the road where you have a business that you're thinking about selling, somebody's interested in it, they're going to be looking to you to make representations and warranties to them that you own the business and you own the intellectual property rights in your business. If you haven't registered your trademark, you may not be able to make those representations. You may not be able to close that deal. So tying down those rights early on can be very important to your future success.
Yeah, and especially in a world where Facebook thrives and Facebook, has this tendency to buy up smaller companies that come up with great ideas or innovative ideas. One of the things that people don't realize is when they put a dollar figure on the value of a business that a larger company is going to acquire, what Jim just referred to, the intellectual property of the business, is a very important component of how valuable the business is.
And I guess we ought to just ask this. We're operating on the assumption that people generally know what a trademark is, but in case there are some who don't really have a good sense of it, all a trademark is a word or a symbol or a logo, something that represents the provider of the good or service. For example, the Nike swoosh, you're all familiar with that. Even without any words associated with it, just that symbol by itself stands for Nike. You can't use that to sell some other type of sporting goods or anything else. I mean, if you wanted to create a sporting drink and put that swoosh on it and say, hey, people might like that. I mean, that's Nike's, even without their name on it, they own the right to that, the look and feel of that mark. So it can be words themselves, it can be logos, all those sorts of things. And we often get questions from clients where they're saying, well, can I copyright this? Can I trademark this? Copyright is an entirely different issue. Trademark is the symbol that represents you as the supplier of a good or service.
Number 2, I'm only giving away an iPad. What could go wrong?
Well, I can address that one a little bit. If you're going to give away a good, there's a number of ways to do it. You may have heard of contest rules or sweepstakes rules, but there are important distinctions between those things. A contest, which is the safer way if you're going to give something away, a contest is essentially a game of skill. If you ask people to submit their best photographs of something and you're going to choose the best one and the winner will get the prize, that's a game of skill. That's an easier thing to do under the law, an easier thing to protect. In contrast to that is a sweepstakes, which is basically drawing a name out of a hat, where it's totally random as to who's going to win the prize. And the reason that distinction makes some difference is in every state in the U.S., it's illegal for you to run a lottery. You're not allowed to run a gambling competition. And if it's total luck as to who wins, that's a lottery, or that's gambling. At least if the people have to buy something to get involved in the game, or they have to provide you something of value. So if you're thinking of giving something away, particularly if it's something of real value, you need to think about whether you have to create rules for your contest or sweepstakes, whether you may have to register that contest or sweepstakes with different states throughout the country. For example, Florida, if your prize value is over a certain level, you have to register with the Secretary of State of Florida. Not all states require that. If you're giving something out and you're advertising it over the internet, well, guess what? People in New York and California and Rhode Island can access that. So you better make sure that your rules are consistent with what those states require you to do. And that, as you can imagine, that's very tough to do on your own. That's one of the services we do provide. And most of you may not be at that point right now, but if you get there, you need to be careful with it. And I would almost offer this analogy. If you're doing a little giveaway at a conference like this, let's say you're going to give away an iPad or something. If you didn't register the contest, you're unlikely to run into any issues there. But if you're giving away a trip, we've heard about clients giving a trip for 2 to Europe. The potential legal liabilities there are huge. People are traveling overseas. Somebody could get injured. Somebody could get off the plane in Italy and get run over by a car. Who do you think they're going to be looking to blame for what happened? They're going to be looking to the person who gave them the prize. And so that's why we can work with you. Again, I'm sure a lot of you aren't at the point of really thinking about that, but for the businesses that are, or if that's something down the road, you need to be very careful because you really have to lawyer that up to make sure you're not leaving yourself exposed to great risks by doing that.
And if you've ever been, I know at a certain time of year when McDonald's does that sweepstakes where they have a little game pieces and they play Monopoly, if you ever actually look at that stuff, it's like this long, because it tells you don't actually have to buy the Big Mac to play. That's one of the rules of contest law. You have to have a non-pay-in way for people to play. And the reason you see them this long is because they're complying, a company like McDonald's is complying with the rules of all 50 states to be able to run that contest. And what I find my blogger clients do, they don't necessarily think of themselves as running 50 state or national businesses, but every blogger essentially does. So if you're running a website devoted to a discussion of certain issues, let's say, women's health issues, and you decide you're going to give away a prize basket of women's health things, there is a lot to consider, because you not only are worried about the rules of whatever state you're sitting in, writing your blog, you're worried about the state where the winner might be, or any participant. So it's just really something to think about. Yeah, go ahead.
A question for you, because you mentioned you have a lot of blogger clients. Are you familiar with like Rafflecopter, for example? What's your take on those type of little widgets that you can embed in your blog that have kind of like these default terms and conditions, and we give away a free copy of a book that we do a book review on, or like for a crafting blog, for example, we do a lot of giveaways on supplies and.
Right. When you're using a third-party service like that, in most cases, the third-party service provider has taken on the obligation to understand that the rules of contests and sweepstakes are being followed. And if you actually look when you sign up for something like that, it'll tell you. But it's also, and I'm not speaking specifically to Rafflecopter because there's a few out there, it's also probably going to put the burden on you if something goes wrong. And so those are safer procedures to use, because those larger organizations that do this, routinely, that's a service they provide to enable you to run those types of widgets and contests. They're great because they've kind of done the groundwork for you. But the downside risk is if there's a problem, they're going to put it on. Usually the contracts or terms of service.
They make you sign off on it saying like it's all on you.
Put it.
It's helping you streamline the process and gather emails.
And a lot about law is very practically driven. As Jim just mentioned, if you're giving away an iPad here at your booth, it's not that you don't run into a contest or sweepstakes rule violation, it's that you're not likely to get caught doing it. And as small businesses in particular, you have to weigh the cost-benefit analysis. Would I recommend that you go behind the app or the widget and figure out whether they've done the research correctly? It probably doesn't make a lot of business sense for you to do that. So then you have to think about, okay, I don't have the resources to hire a lawyer to make sure that my third-party provider is following the rules. My third-party provider is putting me on the hook if something goes wrong. Make a business decision. I'm going to take the risk. I'm not going to take the risk. That's all you can do at this, this level.
Distributing content via third-party sites is safe. Monica?
Yes. Well, the first thing that you should do if you're going to share content via any third-party site is understand the terms of service. This can be a challenge considering if it seems like they're changing by the minute. Could be on purpose. But it's important for you to understand what you're doing when you're uploading content into these sites. What we do at the Herald is share links. This way we can expose our content to our Facebook and Twitter audience without having to upload anything and possibly give up some rights to this content. Yes?
I have a question, I'm sorry, it's about that. I work at many different television stations. There's always a practice of utilizing YouTube video to complement, let's say, a story. Let's say if it's Venezuela, for example, okay, let's say that Chavez died and blah, blah, but we don't have the content. You go to YouTube and you find it in the content. My thing is this, do we use this or don't we use this? And so it becomes an argument in the newsroom when we want to, because we are actually at 5 o'clock, 6 o'clock, or 7 o'clock in the evening, we are distributing a product that comes, not in a newspaper, not as an iPad, but it's a content that you see and you watch. And what if you are the person who actually got this shot of Hugo Chavez's coffin? there's no, like, I don't know if I'm making sense?
No, yeah.
No, that makes sense.
She's like, you know, it's like, some people say to me, well, like for instance, yesterday, I was talking to my sister about this, you know, well, she goes, well, maybe if you could use only 10 seconds.
No.
30 seconds. Or very new.
30 seconds is the default.
What's the rule? I don't want to get sued and I don't want to lose my job. So don't take my picture.
At the Miami Herald, what we like to do is if we see a video that we want to share, we just, if there's, usually there will be a story accompanying the video, and the video is just used a little bit of context. We'll post a link to the video. Sometimes we'll embed it in our video player, but the traffic will go into YouTube. So we're not downloading the video and repurposing it, re-editing it, and taking snippets from it. We're attributing it to the source. And in that way, we feel that, you know, we're covered in that way. But most of the time, we just choose to post the link in the story and talk a little bit about what the link is about.
What happens when we work in television? I mean, it's just different because
You can't do that.
Well,
I'm not sure.
can we just include the credit of the site or?
Was that kind of super huge room compared to YouTube?
No,
We were told there would not be any difficult questions today. So
no, here's the thing. Well, here's the thing for television content providers. You are absolutely correct. There is somebody out there who owns that copyright. This particular hypothetical is going to be governed by 2 layers of copyright law. The person who created it and uploaded it to YouTube. So you're going to have to go to YouTube's terms of service to see if uploading a video to YouTube transferred copyright to YouTube, because then you got to worry about YouTube also. But there is in copyright law the concept of fair use. The trouble with fair use is it's a case-by-case analysis. There's a bunch of factors. Are you killing the market for the original work? Have you taken a larger portion than was necessary, you know, sort of the portion you've taken compared to the whole? Is it a commercial purpose? Usually news gathering is not going to fall within a commercial, or news dissemination is not going to fall within a commercial purpose, even though you all make money off of doing that. The problem I have with my smaller clients caught in this position is that if YouTube comes after you, or the original content provider files a copyright infringement lawsuit, you are now a defendant in a lawsuit. And so the Miami Herald's practice of getting licenses beforehand is a risk management practice that minimizes the risk that they end up getting sued. The Herald can afford to do it. If you cannot afford to do it, the advice that I generally give is, yes, you may get sued for copyright infringement. The guiding post for you should be, have I used just that which is necessary to tell the newsworthy story? If Hugo Chavez keels over, it's newsworthy. You know, clearly that's, you know, taking a snippet to show his coffin to tell that story may ultimately be a fair use. You just have to mentally prepare yourself for the fact that you know, it's kind of, we were talking earlier about the sweepstakes. Small business owners have to make cost-benefit analyses day in and day out. Technically, you may be violating copyright law. If you're using a small piece as a part of a larger story, you're much better protected than if you just stream it right on your site as if it was yours. Crediting it, and you see it all the time, courtesy ABC News, courtesy whatever. It helps, but it doesn't absolve the liability, you know? So,
You know, and I'll take your question 1 second, but, you know, so much of this is, I think as Deanna mentioned a moment ago, thinking through sort of the common sense of it. You know, if you're out on the highway and the speed limit's 70, you probably feel pretty confident driving 75. You're not going to get in trouble because you have experience with that and the violation isn't so bad. If you're driving 95 miles an hour, you're running a much greater risk. So in this context, you know, with what's going on over in the Ukraine right now, if people are posting video from the Ukraine of here are the Russian troops invading this fort or so forth, they are likely trying to get news out to the world. And they are extraordinarily unlikely ever to come out of the woodwork and say, aha, I caught you on a copyright violation and I'm going to sue you. I mean, that's, you know, common sense tells you that that's not going to happen there. David Letterman announced last night on his show that he's going to retire in 2015, and then he did an interview on the news this morning. If you took 3 or 4 minutes of that discussion from his show last night, owned by CBS, an American corporation that makes a lot of money off his show, and you repost that, you're a lot more likely to get in trouble about that. So, you have to think about where you're getting it from, why did someone post it, what was their thinking. I mean, that may help you make the decision. As Dana said, it doesn't clear you if someone from the Ukraine decides, aha, I found someone in the US, I'm going to sue. You're still in the same boat. But your common sense tells you a lot of time that the newsworthy things you want to use may in fact be things you can use without a great concern about liability.
The question in the back first, yeah.
Well, you said, let's take that hypothetical. Somebody in Ukraine, under what law would that suit occur?
Well, that's a great question. I mean, the way U.S. copyright law works is if you're here in the U.S., and you jot something down on a piece of paper, or you take your phone out and you videotape something or create a video of something, you immediately own the copyright simply by creating that content. But if you were going to sue somebody over that, there's a number of other steps you have to go through, including registering it with the Copyright Office. And frankly, most people's 30-second videos on their phone, they're never going to spend the time and effort and hire a lawyer and all those things.
In that case, where would you prosecute that? In Ukrainian court?
Either. Yeah, I mean, the Ukrainian who was upset about it, assuming, as Jim suggested, that the creation of this video created rights, although copyright has a lot of international treaties that try to standardize some of this stuff. 2 things could happen. The Ukrainian, and again, this is where we get into how practical is it, can come to a U.S. court where he can definitely get jurisdiction over the U.S. blogger, or he can sue in the Ukraine. And I've had clients who get sued in other countries. They don't even know they've been sued because there's no practical way. I just actually got somebody out of a situation in Switzerland. A client had been sued for trademark infringement in Switzerland, had no idea until the final judgment was mailed. the plaintiff from Switzerland made sure to make sure my client knew about the injunction, but didn't do anything to let him know or let it know about the lawsuit. So you have to be careful because, some of you may not be streaming into the Ukraine, others may. So if your content is accessible in other countries, there is a chance. Again, I think in this hypothetical, as Jim suggested, probably a very low chance. This person wants the information out. This person, wants the world to see what's going on there. But, there are some real scenarios like my client just dealt with where he,
But as a practical matter, unless there's a treaty between the U.S. and that particular country, they can sue you to their, till they turn blue, and it's going to have no repercussion on you here, right?
it's hard. I mean, they get an injunction in the Ukraine, and then they have to take steps to enforce it in the United States.
It would be
very
difficult for them to do that.
Dana's one of our partners.
So this is going to be a
So this is gonna be
really
fun.
bad question.
No, I'm not going to ask the question, but I was going to address just one more aspect of because I deal with a lot of visual mediums, and sometimes we work it into the story. And I know the Herald had that we were talking about beforehand, or when that guy on Facebook, remember when he killed his wife and he put it on Facebook? And, part of the story was it was on Facebook. So sometimes, I counsel clients, if there's some way you can work it in, the fact that it's on Facebook, or if there's an investment scam and they're using Facebook to advertise it, or they're using, in some ways you can make that a part of the story, and I think that helps, although I think that really helps the fair use analysis. I think of that generally as shooting wide, but you don't have to, but if you can somehow weave it in that somebody did something and posted it, I think you have a better chance at fair use.
Yeah, question here. These are great, by the way. Thanks for asking such good questions.
Common licensing to use images or videos. How does the copyright affect those sites? They put it up for free images or free videos, and they're under common licensing. They allow people to use for whatever purpose.
Right. Well, but you're saying that the provider of these images has
Agree to upload to that site, so they can't come back later and about whatever you use that image or the video for, correct?
Yeah,
Yeah, there are the free commons sites where people put their material up for use. They may still put some limitations on what you can do with it. For example, you can't put it in a commercial advertisement, But so long as you comply with those requirements, yeah, you can certainly do that.
And it goes back to the checking the terms of use frequently, as Monica mentioned. They change often. They change for my blogger clients often, but then they also change for the YouTubes and the common media and things like that, where, you know, it's worth every now and again just making sure that you're not exceeding the license that's provided. I've seen them where you can use images, but you can only use, actually, this is another real case. We licensed images, but what we didn't catch was that we only licensed the use of 25 images. So the plaintiff, of course, argued that the image at issue was the 26th image. And then you have to really go in and figure out, well, was it the 26th image we downloaded? Because if it was the 26th image, we exceeded the scope of the license. And my client wasn't even aware that it had only purchased a 25 image license. So just be mindful of, you know, what you're getting into when you sign up for these things, so you know.
Yeah, I believe there's a site called Creative Commons.
Yes.
Where you can go and you can upload material or you can download material. And I've used some of the material, stills from there to documentaries and all that. And I did go in there and read the license. But the question is, on some of the older archival material, when does the copyright expire?
A long time. It's like life of the author. It used to be plus 70 or
Yeah,
plus...
70 past the death.
Yes.
Yeah, but look at Mickey Mouse. He's still under copyright, right? I mean, they find a way.
That's the problem. I mean, Disney drove a lot of that, was to keep their copyrights alive. The legislation has changed. I mean, copyrights, anything you'd be interested in using, you know, that's like been videotaped is almost certainly still under copyright.
Well, unless it's a government documentary, which is public.
Yeah, I mean, there are things like that, and you know, tracking down the rights can be difficult. Trademark, if you know a trademark name, you can go to the trademark office and very quickly look up whether that's registered. Now, that doesn't answer all the questions about whether someone owns a trademark, but at least you can do that initial search very easily. Copyright is much, much harder to look up because if it's a video, like think of the Zapruder video of the JFK assassination, how would you look that up if you didn't know the name of the man who created the film? I mean, how would you go to the Copyright Office and even look that up? It doesn't have a title.
But if it's a War Department film on DC-3 planes from 1943.
That's typically
yeah.
public domain.
Well, yeah, if it's a government creation, but if it's not, it's, you know, every time,
Well, you're safe with anything that you know it's a government.
if it's a public
Well,
record.
and it depends on the content too. For instance, for the Herald, I know that our pages, I think our copyright ends in 1922, 1923 right now. So everything else before that is in public domain. So for photography, it's different. For newspaper pages, it's different. For music, it depends on what you're looking for. So it is complex. Yeah.
Monica, if you can address the metadata portion of how you work at the Herald with
Yes.
and I think that would also address on the flip side when you're trying to protect your own creations.
So a lot, what we do with our content at the Herald is make sure that the metadata, particularly the rights metadata, is very clearly stated. We have very specific language for how we describe staff content, content that has been acquired through wires or handouts, which is content that people give us to, from, relatives or whatever content that may be that we haven't taken or purchased. So we make sure that everything is properly tagged in our archive in case moving forward we ever want to reuse it, or also in case anyone wants to purchase it. We license a lot of content at the Herald, and the reason why being able to make money off of your product is easier for us, it's because we know where everything came from. It's very easy for us to clear rights and make sure that this is something that we can sell, let's move forward with it. So metadata is really important both ways. For you to protect your content and also make sure that people know how to contact you if they're interested in purchasing it. And the flip side is trying to figure out where content came from. It's difficult to do when you're getting information off of the web. Let's say when you upload content into Facebook or Twitter, a lot of the metadata from the photo, let's say, will be stripped away because they repurpose that to make it a little smaller so that it fits better in their servers. So your your information, your signature may be stripped away. I think that the last time I checked with Facebook and Twitter, the two fields that they can see are the byline, which would be your name if you took a photo or if it was your story, and the copyright notice. So make sure that you beef up those fields when you're entering metadata into your content so that they can, if somebody's interested in purchasing your content, they can contact you, even if they found it, through some third or fourth version in a Google image search, which can very easily happen. People download images from Facebook all the time. They post them in blogs, they move them into Google, and then there's no way to figure out where something came from.
And Monica, there was a website you
Oh, yes.
talked about.
There's this software developer that created this. It's a really cool embedded metadata de-encryptor where you can post a link of an image that you find or a document, and it tells you what metadata is embedded in there, including copyright metadata and who created the content. So, that's a great way for you to figure out if you want to use something, if you can, and how to contact the person. You can do it using other software programs, but this is free.
I need a visual, so I'm just going to pull something off of Google. What are the dangers in that?
Well, we've just talked a lot about that, right? One of the dangers is you don't know who's going to come out of the woodwork to claim that it's theirs. So that's, the copyright side of it. The other side of it is you got to make sure that you keep the context correct to the picture. In media law, we all know about, the sort of the cases where the person is perceived to be promiscuous, as in this example, or somebody who has consented to the use of their image, for example, for a women's health magazine, but then that image ends up in a smoking advertisement or something that's very antithetical to the individual involved. So, as much as copyright is an issue, and we've talked a lot about that, context is key. You want to make sure if you're trying to find a stock image that you don't step outside the context of what that stock image, even assuming you have a license, you don't want to step outside the context of what that image is, intended to be used for. So in this example that we have up here, this is an article about the mating habits of the suburban high school teenager. And it's based on a Massachusetts case that basically says, look, this girl in this picture is being used to illustrate a story about promiscuity and drinking and all of this stuff that goes on in high school. And 100% of the time, the plaintiff is Mother Teresa. 100% of the time. Because if this girl was really promiscuous, she wouldn't bring the case, right? But as luck will have it, it's always going to be the person who has an untarnished reputation, religious, everything bad about, as you're a defendant, she's going to have everything going against you in her favor. And so in this particular case, the court said, look, this could be construed to suggest that this woman is promiscuous.
And just to be clear, I think what happened here was the publication used a stock image. This isn't from a party that they went to and covered and interviewed these people. They just pulled an image to illustrate the concept. This girl, in fact, had nothing to do with the story being told, but they thought, well, she illustrates it, and who knows what her name is? It doesn't really matter. Well, she knows what her name is, and their friends do, and when they see this picture and associate her with the story, all of a sudden, the writer of the story is saying something about this girl who he's never met and never seen before. That wasn't the intention, but that's how readers take it. And how readers take it is very important as to whether you may have some legal liability.
And that happens with hot button issues. Even models or so forth who have images taken of them and then they license them to a company like like a clip art service or Digital Juice or like one of those like clearinghouses. And so you have to be a little bit careful because hot button issues, pregnancy, sex, drugs, alcohol, those are the types of things where somebody comes out of the woodwork and says, look, I took this picture and I said they could use it for, health and fashion, but now you're using it in a different category. So, it's always about checking the licensing and making sure you don't exceed this scope of the license.
Well, and the thing that I think we've all seen happen with the question about, can I just take an image off of Google or take an image off of Facebook? How many times have you seen a story where some terrible crime occurs and the person who committed the crime, his name is leaked out, and somebody goes to Facebook and says, oh, that's the name, that's his picture, let's put it on the news. Well, it turns out there's 6 guys in town with the same name, and it's the wrong guy. You have just walked into a major lawsuit doing that. So it may not even be the copyright issues, but if you're going to take information from a source and you don't know whether that source is accurate, you need to be very, very careful about that. I mean, there are even situations where people create fake Facebook pages. It's not even them. They may do it to embarrass somebody or for some other reason. And you go there and you assume, well, that's their Facebook page. This must be legitimate. You don't know that. I mean, there's a huge risk in doing that, particularly if you're going to report something negative or inflammatory about someone.
And Anna Clara has kind of transitioned us to a corollary of that, which is if you break it first, and social media has kind of this dual thing. It's a really fast publisher. We saw it this week at the Fort Hood shootings. So many people on about the shooter on their base through social media. And so it's a wonderful thing in that respect because it can break news faster than the Miami Herald can get to its computer sometimes, although I'm sure you guys tweet and other things too, but social media, clearly, but social media can be a really quick news breaker. On the flip side of that, it can be really, really wrong, as in the case of Adam Lanza's brother here, who the police had initially identified as the shooter involved in the Newtown shootings. And next thing you know, he's taken to his social media profile to say, hey, it's not me, it's not me. So the one thing that social media has to be very careful about is in being that breaking news source that it's so good at being at, it has a high risk of being wrong. And when you post, for example, that this guy just killed 23 children in Connecticut, that's a lawsuit waiting to happen. In fact, I think one of his friends says you should sue them or something, which is a very valid point. Now, I'm going to tell you in this particular example, the information came from the police, and as content providers, you have a privilege to report what the police are telling you, even if it turns out to be wrong. But in other instances, you just have to be mindful of the fact that you want to go, I think, what was the one with CNN too? CNN was reporting...
Was it Gabby Gifford?
Oh yeah, that Gabby Gifford had died when she obviously hadn't. So, it's the major news organizations do this too. They get information out quickly, but, breaking news and...
So if you get it wrong in a newsroom, in a television newsroom, you have the news director, the executive producer, the assignment editor, you have the reporter, you have all these layers. Wow. Okay? And then you have people. Right? Like what you were saying about the Newtown thing, that's what happened to us.
Yeah.
I work for a local TV station here, and we have that picture. And it was him, oh my God, we got it, but then I was like, this is not it. This is not, I was doing that. I was being el archivero del newsroom.
Right.
Because I didn't want to use that picture. Okay, I said, you do it. Who the heck is going to get fired? I mean, not fired, but I would. But who the heck is going to be taking the responsibility of, ultimately utilizing that picture? Is it the news director? Is it the executive producer? I mean, who is the one to blame?
Yeah, well.
We have like 17 people in the newsroom telling you it is, okay, right now, in a very nice environment, we can talk and have this discussion and all this kind of stuff about it. But guys, I have a deadline at 3 o'clock in the afternoon.
Yeah. In the real world, they're going to sue the organization, the corporation. That's where the money is. But there's also risk that you as individuals, many times in our defamation actions or invasion of privacy actions, I actually have one now. They name parent companies that have nothing to do with it. Then they name the network that's there. Then they name the producer of the show and the reporter on the show and the cameraman and whoever else they can name. The practical reality is that the corporation is the one with the money to pay the judgment, so that's most likely the primary focus. If they get a judgment against an individual reporter, they're not going to collect much. The dynamics, the other part of your question, like who's going to take responsibility, from a practical perspective, there's going to be an internal, at a large organization like the Miami Herald, they're going to figure out, how did we make this error? They're going to make a conclusion internally that either the reporter messed up or the editor, they're going to figure out where that is. Practically, most often, we're going to have a unified front until that lawsuit's over. And then you see, you know, people lose their jobs if they make blatant errors. Something like this, though, where the police are reporting that it's Ryan Lanza, you know, I don't imagine that in a large newsroom anybody would necessarily get fired over that. Those are business decisions that we don't make as lawyers. It's more when the internal investigation reveals some sort of malfeasance, a fabricated interview, a misleading of a source. Those are the types of things that end up getting the reporters and journalists fired over these types of things.
And there were a few other
If I
examples we had as well.
I just wanted to make one comment here, though, which is, you know, it's our job to worry about this stuff. That's what we get paid to do. But we don't want to create the impression that you don't have the right to talk about anything, don't say anything, unless you have interviewed the person laying in the street with a bullet wound. You can't, you know, it's not that bad. The First Amendment is a very powerful thing, and we spend a lot of time defending speakers of all kinds, newspaper publishers, bloggers, for their speech with an extraordinarily high success rate because the law is in your favor. The law wants to allow speech. But one of the problems is we may win a case, but it might cost a boatload of money to get there. And that's really the thing you want to avoid, is having to hire a lawyer in the first place, although we'd be glad to have you hire us. I mean, that's, you know, that's the real risk for most organizations, is the cost of the lawsuit more than the cost of the judgment. So, you know, we're giving you this advice to be careful and think twice about what you do, but we don't want to turn you into, you know, wilting flowers about this. You have a right to speak.
Yeah, what Jim is saying is be human. If you've published that it's Ryan Lanza that has shot these 23 children in Connecticut, the minute you learn that the police are really looking for his brother Adam, tweet that out or put that up on your blog or whatever platform you're using to communicate, because that shows your journalistic responsibility, number one. It can, in a lawsuit, lessen the damages, because, okay, yeah, we identified Ryan Lanza, but 48 seconds later, we put out another tweet that corrected that information. So, you know, I think for my bloggers, the moral compass is the same as any other content provider or your traditional journalist. Find your moral compass and then consistently adhere to that. Yeah, I mean, everybody gets it wrong. We're not going to suggest that the most major news organizations in this country have all been sued. I would venture to guess all of them at some point have been sued for libel. It's going to happen. It's less likely to happen to the smaller players because your reach is not perceived as large, even if it is. Everybody knows that everybody watches CNN because intuitively people know that it reaches every household with cable. You might have a blog that reaches 16 million people a month, but nobody knows it because you can't. It's not as intuitive as it is for a TV station or the Miami Herald. You know, we can guess circulation numbers, we can guess viewership. For websites, y'all can get that information because you can get your hits if you have those services. But from the people looking to sue side, you're not perceived as creating as much damage because you're not CNN. You know?
So just to scare you a little more, what about the myth that you can't defame someone on Twitter?
Does anybody in the room use Twitter not just for personal uses, but to provide content to your, people who like your sites and your blogs? Okay, so you're all doing it. The thing about Twitter is, as defamation lawyers, context is key. So I was actually thinking about this example. Everybody in Florida is familiar with the Casey Anthony case. And in that case, there were a ton of what I call bit players. There was the fiance, there was the grandparents, there was the meter reader, there was, some of the investigators became characters in and of themselves. And so you have to be careful with context because you don't have, if you write an article or publish a blog about what's going on in the Casey Anthony case, and here's an example. Casey had a fiance who had a father who was a little bit out there in his religious beliefs, according to some. He wasn't a mainstream, he wasn't following mainstream religious beliefs. If you write a complete article about that, the reader gets a chance to kind of decide for him or herself whether to think this guy is crazy or to think, that this is a legitimate, his religious practices are legitimate, or to draw its own conclusion. In the Casey Anthony case, the grandmother speculated at one point that Kaylee, too many C's in that case, Casey, Cindy, Kaylee. At the time, I couldn't keep it straight, and I still can't. The grandmother, Cindy Anthony, had speculated to her private investigator that maybe Kaylee was the victim of a human sacrifice ritual. And lots of publishers wrote articles about it. Some got sued and won because you could read the article and make a decision for yourself, kind of what was going on. But I was thinking on the way down here, if you simply tweeted, you've got 140 characters, so you tweet, Kaylee Anthony, victim of human sacrifice ritual at the hands of former fiance's father. There's no context for a court to look at. You've basically said the same thing that every one of those lengthy articles said, but you only had 140 characters to say it. And in saying it, you lost your context, that it was coming from a grieving grandmother, that it was said to a private investigator, and that those statements were turned over to police, which is a very important fact because it makes it privileged. And then the police released those records to the public pursuant to public records laws. You're missing a lot of context. The articles that came out about this clearly showed both sides of the story, went in great detail about his religion and how it was recognized by several ministry organizations around the world. It had been recognized for hundreds of years. So all that stuff can be provided in a lengthy article. On Twitter, you get no context. So if you get sued, that's what everybody's looking at, your 140 characters. So you want to make sure when you're tweeting that not only do you keep in mind the information you want to get out, but keep in mind where it's coming from. So, in that particular example, you might, and Twitter's so hard because with so few characters, you have to people can't even spell anymore because we have to make up new ways to spell words. But, you might want to add, according to police records, or, something that prevents somebody from coming after you for it because they can see that you have a source that provides a privilege, or something that provides both sides. Human sacrifice ritual, though, and you don't have enough characters, you have to figure this out, it's hard, though religion has been recognized for thousands of years, or something that kind of takes the sting out of it. That's, to me, the biggest problem with Twitter, is you just don't have a lot of context to provide.
And Deanna, you have a Twitter handle, right?
I do, at Free Speech Law, yeah. So you can follow me there. I try not to defame people, but I make no promises.
So how about the Courtney Love, the first Twibel case, Twitter libel? Has that informed your own tweeting?
I have to say,
You've laid off the heroin?
I've laid off defaming my fellow lawyers. No, just kidding. I have to say, when I tweet personally, and I have to say a lot of this is uncharted territory, if I'm going to tweet content that's not my own, other than Anna Clara's tweets or the firm tweets or something, I always try to trace back to the source and just point people there. I very rarely, in the Courtney Love case, she had made a comment about a lawyer being bought off in a case. You're not going to see me making value judgments about people on Twitter. I more worry about the situation where I'm inadvertently stealing somebody's content. So if a friend of mine tweets a Miami Herald article, I'll go to the Miami Herald's website and click on their little tweet button because at least that tells me Miami Herald wants me to tweet it because they put the button there, you know? And that's kind of how I handle like the retweet scenario.
And I think implicit, obviously, in what Deanna is saying and Anna Clara's question is the medium doesn't change the law. The fact that you say something defamatory about a person in a newspaper or on a television broadcast or in a blog or in a tweet or wherever you put it, so long as there are readers, so long as there are people who see it, it's all, the same law applies to all of it. So there's no, bar the door exception because you did it on Twitter as opposed to in a more traditional media.
Now, in this case, Courtney Love won ultimately, but what does it say for people who are content creators on social media that she had to go through the trial itself?
Well, I mean, I think it says, it sort of echoes what the point I just made, which is, and again, cost-benefit analysis is someone going to sue you, if there aren't that many people reading your tweets and they're not that famous and they don't think you have a lot of money, perhaps not. But if you're Courtney Love and you've got a bank account, you can be, you need to be on the lookout for what you say on your Twitter account just as much as if you went on television and said it. And she did win the case, but not because it was on Twitter. I think they determined that her mental state when she made the statement was she believed that this person had been bought off, so she wasn't at fault when she made the statement, which gets into a whole other issue of something we might try to defend you on, but but she could very easily have gotten hit for a large judgment here.
One other thing about this is when you're running a blog or a newspaper or a television programming, one of the things that I see, I follow a lot of my clients on their Twitter accounts, and one thing that I see that makes me happy as a lawyer is when they don't try to recreate their online content, they just try to point you to it. So, for example, the Herald may point me to an article on their website. I think that's kind of a safer way to go so that then you have the full package or the full piece of information rather than trying to truncate it and losing that context. If it's sports scores, that's fine. But if it's some sort of investigative piece or something that has the potential to defame somebody, an investigative piece, a consumer report, a piece involving some sort of scandal of some sort or domestic disturbance or all those sort of things where people tend to come out of the woodwork, I do find it safer to kind of use your Twitter account to point people to the larger piece of content if you have something that,
And this problem comes up a lot in television news as well, because there'll be a news story that's 5 or 6 minutes long, an investigative story that gives both sides of the story, some nuance, and somebody's got to do a 10-second promo of that story. So they pull out the soundbite, the part where somebody looks like they've committed a horrendous crime, and that's the promo. Well, you see that TV advertisement, it stands by itself. If that defames somebody, you've got liability there. So that taking things out of context and taking just the gripping part, you need to be careful of that because you do lose that context and nuance.
Yeah, at our firm, we don't approve promos without having approved the broadcast. We'd like to see both. A lot of times the promo wants to run first, so they just want to send us to promo, and we're like, well, we need to see the story first to see if it bears out what the story is. And often that's just a product of two different markets. The marketing department and the news department are writing two different things. So make sure you have cohesion between your departments if you have multiple people working on these things.
We've covered a lot of copyright issues, and before we move past the copyright issues, I wanted to give Monica a chance to talk about a few of the websites that she wanted to also point out, schema.org, and we've spoken a little bit about the Creative Commons.
But the Creative Commons, I think most of you are familiar with this website. This is a place where you can go find content to use for, you could say for free, but also this is a place where you can go get a license as well for your content. They have several different types of licenses. Some of them limit commercial use and derivatives, but you can go in there and sort of get a better idea of, well, how you want to expose your content to other people and how you want your content to be used out there in the internet. So this is a good way to get familiar with the language that you need to use. It's a fantastic website. If you want to be more familiar also with metadata standards on how to structure metadata so that it sticks to your content everywhere it goes, schema.org is a great place. It's free. You can pull metadata schemas right out of there and plug it into your blog content management system. It's a great, if you're not doing that now, you should start after you leave. Make sure that your content is being properly tagged and that you're following a structure that matches and is interoperable with other systems so that it travels well moving forward.
Maybe a little bit off topic, but when you upload material on YouTube, which people here probably have done, is it safe to assume that the material is yours if you filmed it originally, et cetera, but it's housed with YouTube? I mean, does YouTube have rights over that, or?
I'm not sure if you're not giving up your copyright, but you might be licensing your content in some way.
Yeah, I mean, that's where you have to check the terms of service of the site that you're uploading to, whether it's a photo sharing site or a Facebook or a YouTube. It's the typical scenario is that you still retain your rights, but they take on non-exclusive rights to distribute, which means if they want to distribute it further, they can. But it varies depending on which site you're using. So you want to make sure you check if you're uploading there.
There was I don't even know, you guys might have this case in front of you, so I don't, if you don't want to talk about it, that's fine, but there's a case of a kid named Max Jackson from FAU who took pictures of the Color Run, and Color Run reached out on Facebook because he posted his pictures on Facebook and said, hey, can we use a couple of these to post on our Facebook account? Fast forward a couple years later, he walks into a sports authority and sees his pictures blown up, huge. He gives them a month or something like that to pay him for that, and instead they turn around and sue him for claiming to be an employee, and they said that he had something called, he had given them, by letting them use his photos on Facebook, something called an implied license. Is there such a thing as an implied license?
There is such a thing. I'm actually surprised it's not an express license, to be honest, because a lot of times these contracts are this long, and even lawyers have a hard time discerning them. But yeah, there is an implied license concept in copyright law.
So they can do that because it was just a Facebook conversation between him and a marketing guy from Color Run saying, hey, do you mind if we repost some of your photos on our Facebook page?
See, that doesn't sound like enough to me.
Yeah,
I don't know
doesn't-
the exact facts. This isn't one of our cases, and I don't know the precise facts, whether a document exchanged hands between he and the guy.
It wouldn't shock you to know that the people representing Sports Authority, perhaps seeing themselves in a position of weakness, decided, let's strike first, because we may be able to get rid of this guy that way. So, the fact that they're making the claim doesn't in any way mean the claim is legitimate. But he absolutely, if there's no express license and he didn't on that Facebook account say, sure, you can use these pictures and use them for whatever you want in the future. I mean, if he didn't go that far, I'd rather be on his side of that case.
Yeah. And that's the thing about copyright law in this day and age. When he uploaded that photo to Facebook, Facebook took on some ownership in it.
For instance, those people never would have seen that photo. I mean,
Right.
they never would have, Color Run would have never connected to him.
Right.
Right.
And then Color Run connects to him, and did they exchange documents other than a few messages? If all there is a message that says, sure, go ahead, I'm concerned for Sports Authority in this case. And then you have to look at how it got from the Color Run folks to Sports Authority. Like what?
That's like a partnership. They're like
Okay, all right. So yeah, I mean, this is really tricky, and for the poor fellow who just let the Color Run people use his Facebook picture, it's an expensive proposition to have to figure this all out, So that may be why one of the strategies is make him defend himself.
What you're giving up,
One thing that he could have done is hosted the image himself and uploaded a link of the image. And then Facebook has a way where you can view the content without having to upload it. And I would say that's host the content yourself and then share it.
It's certainly safer.
The video is not a practical thing.
Because of your server space and things like that, yeah. No, I know, it is.
But that would be
There
the
was a
safest
question
thing.
I'm sorry, there's a question over here, too.
I attended an event sponsored by a brand and took a picture of some of the products they had. Delighted to share the news about this new product coming out. Or rather, I was under the impression it was already out because they were giving it to us, but we were the first ones getting it for a sneak peek kind of thing. Tweeted it out, Instagram, Facebook, the whole 9 yards. Rep finds me a few days later, I've been looking for you. Can you take down the image? Product is not out yet. We're not sure if we're using that label. I'm a nice person. I think. Did I have to?
You know, it may depend on how you got invited to the event. For example, if you go to a professional sports game, if you turn your ticket around, there's a lot of fine print about what you can and can't do in the stadium and with images and so forth. So I don't know how you were invited, but they may have invited you in some way through an email where there was a lot of fine print about, and you will or won't do certain things with what you learn there. Yeah, if they don't have that sort of contractual limit on what you can do, then there's no legal reason why you can't report what you saw. That would be fine, but fortunately you are a nice person, so you did the right thing.
Well, and Jim and Dana and Anna Clara and I counsel clients all the time, and very frequently I find myself, we pre-pub things, so we vet them before the stories are published. And we also do what I call postmortems, where you've got the demand letter and you have to decide whether to make a correction. And I end almost every conversation with this. Lawyers can help you identify and minimize risk, but we cannot stop somebody from suing you. And unfortunately, sometimes that happens. You do your best to get it right. You do your best to make corrections when necessary. You feel like you have all your I's dotted and your T's crossed, and you're legally on the right side of it, but there's just absolutely no way to ensure that they wouldn't have come after you, at least in a way that made it cost prohibitive for you to even deal with it.
Bully me into doing so if I didn't just willingly take it down myself.
Yeah.
Right.
And it's hard. And one thing we haven't really touched much on, and I don't even think it's in our PowerPoint, but if you're running a blog that has a large readership and you're generating revenue and it's, your revenue stream is sufficient, you should do this before, but I know as a practical matter you can't. You ought to explore insurance for your business, because there are a lot of companies out there that will write insurance for content-based claims. I will tell you, for many of my clients, it's cost prohibitive. For others, it's not. So if you've got something good going and you think, I'm making a living off of this and this is generating a significant amount of revenue, look into insurance, because then, not that we like the insurance companies to have to pay for this, but then at least you have a little bit of peace of mind that you've done everything right and that jerk just sued for the sake of suing, and you've got some protection.
What's known as errors and omissions insurance.
Yeah, we have E and O policies. My clients have policies that are content driven, that are based on defamation and privacy liability. I have had a handful of clients whose homeowners insurance policies will cover. So, take a look at that. Oddly enough, I had a client once that had a defamation writer. If he committed the act of defamation on his property, he was covered. Well, it was great because he did. So, in the sense that he mailed the letter from his mailbox. So, but it was enough to sort of trigger the insurance company to defend the lawsuit, and thankfully that one didn't linger very long. But yeah, look into general commercial liability policies and things like that will cover content-based claims.
Having a little PowerPoint issues, trouble advancing, so I wanted to ask you guys a question about multi-platform hopping, and for our bloggers who may also have a Facebook page and a Twitter and also an Instagram, and you're in multiple online spaces. Are there any liabilities with going from one platform to another, jumping from, let's say you have your blog, or you pull something from someone else's website and then you post it somewhere, and are there any protections for that in the law as well?
Well, mean, I think it's the same analysis that applies just generally across the board. If you're stealing somebody's content for your website, it's just as bad if you're stealing it for your Twitter feed or your Instagram. You know, you're going to take somebody's photo and somebody else's photo and put it out on your Instagram. So those copyright issues we've already talked about, those defamation and privacy issues that we've talked about, all of that comes into play, and, you know, each individual act becomes an actionable claim. If you've defamed the same person in your web article that you did in your Twitter feed, that you did in your Instagram account, now you have 3 publications to defend instead of 1.
And a little offshoot of that idea that's, again, maybe has been implicit in some of the things we've talked about today. You know, a lot of times if a newspaper or TV station gets sued for defamation, it's not for something the reporter said, it's for something the reporter asked and someone said back to the reporter. It's the man on the street's statement that gets reported in the newspaper. If you publish it, even though it's someone else speaking, and even though you put their speech in quotation marks, and even though you attribute them, if you publish it as a statement of fact, it's your statement of fact. You have to live with it. You are making the same assertion that statement is true as the original speaker is. So in this context of moving across different platforms, if you lift something from a friend of yours blog, something they said that you thought was really interesting, and you refer back to them and you're trying to give them credit, but you're making the same statement in essence, you're in as much trouble as they are if they've invaded someone's privacy or committed defamation.
And then finally, number 11 myth, I didn't take the photo or publish it, I just helped sell it. Is there any trouble with that?
Copyright law is very multifaceted, and one of the things that copyright publishers have is public distribution rights. So, or copyright owners have is public distribution rights. So, you know, what is there, 7 or 8 bundles of copyright rights? Yes, if you're reselling somebody's copyrighted work, you can be in just as much trouble as if you were the one who infringed initially. So,
Can you tell us a little bit about the Elsa Benitez case?
ooh, I forgot that you wanted to talk about that. Yes, I could tell you a little bit. Elsa Benitez is.
What's that? We
actually don't
learned
have
a
to
lot
tell you
more.
a lot,
We
right.
learned a lot more than we can tell you today.
Yeah. Elsa Benitez, for those of you who don't know, is a supermodel who has made her career with Victoria's Secret and other magazines as a swimsuit and other fashion model. She had a habit of, she lives here in Miami, and I hope nobody knows her in the room, but she had a habit of sunbathing nude in her backyard, which makes a lot of sense for somebody who makes their career as a swimsuit model, because she doesn't, you know, she can't have tan lines. It's a practical problem she was trying to solve. She just was doing it in her backyard. A photographer could see through the fence that she was lying in this state of undress, took photographs of her, and then a photo agency whose job is to distribute photos, a distribution agency. The way that their system was set up is that any photographer could upload photos to their website, and then those photos were sold. You know, it's kind of what you just talked about. Can you get in trouble for distributing somebody else's work? And the answer from the Benitez case is clearly yes. The photographer uploaded completely naked photos of Miss Benitez to this website, who had automatic systems in place, meaning it wasn't like, you know, it's kind of like Facebook, right? You put up the picture and there's nobody really filtering your, if I put on my Facebook page a nude picture of Elsa Benitez, Facebook may ultimately learn about it, but they're not screening it initially, you know? And so it went up, it got offered for sale, it sold to several international publications, and it was published in Germany, I think Spain, Canada, Mexico, which is where she was from. So that was particularly troubling to her because it was her home country and she had a reputation there to protect. So she sued the photographer and the distributor for invasion of privacy. And we talked a little bit earlier, you know, who's going to take responsibility. This is actually a great example to answer your question. The photographer caused a stupid problem, right? I mean, he's the one who took the photo, number one, and he uploaded it for public sale.
And he uploaded it against the rules of the photo agency.
Against the rules of the photo agency.
They didn't want these type of photos on the site.
Right. So, practically speaking, though, the photo agency is the pocket, right? The one that has the money. The photographer was a defendant in the litigation. He hardly participated. I think we went to his deposition 4 or 5 times before he finally showed up. But at the end of the day, he never really was the focus of Ms. Benitez's counsel, because at the end of the day, he didn't have the money to pay a significant judgment. Now, this is a woman who, you know, what happens is these plaintiffs come in and they're very big on how they've built their career on modeling this high fashion. I mean, these were explicitly nude photos. There was nothing left to anybody's imagination, and this really had an impact on her, you know, modeling career. I mean, this is the story you're going to get from these plaintiffs. At the end of the day, the agency... All right, I've been waiting. It's Friday. At the end of the day, the case was not tried. Jim and I filed a motion for summary judgment. We argued that, and this is actually something we haven't talked about and should, we argued that our client was immune from liability because it was simply distributing the content of others. Those of you in the room heard of the CDA, or Communications Decency Act. This is the act that protects the Miami Herald when people comment at the end of the story, because the Miami Herald doesn't provide that content. So you run your blog, you talk about something scandalous, and 85 people comment. The CDA is what protects you from liability for those comments. So they do a story about somebody running for office, and somebody comes on and says, that guy is a crook, he's, you know, a liar and a thief, and he rapes little children, because that's always, you know, what happens. This is the most scandalous of accusations. The Miami Herald would be immune from liability because it was content provided by a third party. So in this case, that's exactly what we argued, that the photo was provided by a photographer. He is a third party. The judge disagreed with us. Jim and I will keep quiet about whether we think she was right. And ultimately, our client was put in a very bad situation of facing trial, where we had to talk to a Miami jury about distributing naked photos of a Latina woman, or you know, to try to resolve the case through the settlement mechanism. So,
just to add to that, if there will be another person involved with this picture, that will be twice as hard, right? What we were doing.
well, I'll tell you who the defendants were, because you were asking this question earlier. The defendants were the photographer, the distribution agency, which was our client, and then the folks who had published the images. The practical problem we had, they were large organizations. The practical problem we had is none of them were in the US. So she didn't have jurisdiction over them. I mean, it was a problem for us because we didn't have any other pockets to try to solve this problem.
Yeah, if you can point to someone else, that's often your best defense.
But they were all out of the US and beyond the jurisdiction of the court, so it wasn't like we could expect them to pay the judgment.
The photographer and the subject of the nude photograph were all in the same area, same zip code, let's say. Was this a federal case or a local case?
Well, it happened to be brought in state court here in Miami. You can get into federal court on a defamation or privacy claim if you are a Florida resident suing somebody who is not a Florida resident, and the amount of damages is more than $75,000. You also get into federal court on your copyright and trademark claims. So if you get sued for copyright infringement, you can get sued, or you actually, trademarks have to be, which ones have to be in federal court? I forget. Copyrights have to be in federal court. Trademarks can be in either court.
And in fact, in the Benitez case, we as the defendants tried to get the case to federal court. Generally speaking, we'd rather be in federal court. That's a better place for us to be. You're going to get judges who are better equipped to deal with First Amendment and free speech issues. They all have judicial clerks who are top people in law school working for them. So we want to be in front of those judges if we can, and we came up with some arguments that the
photographer was initially a John Doe defendant, and we were under the mistaken impression that he was a Chilean, well, he is a Chilean national, but we thought that he lived in Chile, that his primary residence was in Chile. But as it turned out, he wasn't. So we removed it when he was a John Doe, and we were in federal court for a while, but then when his identity was revealed, which is a whole nother issue we haven't really gotten into, but when you're the co-defendant, you kind of have to give up the identity of the other person, or else you're really going to hold the bag for him. As it turned out, he was a permanent U.S. resident living in Miami. So because she was a Florida resident and he was a Florida resident, remember how I said you have to have somebody from another state, there was no more diversity, so we got sent back to state court. So, yeah.
I have a question. I have a blog that I was told by the government that a slogan cannot be trademarked. The saying cannot be trademarked, that I had to copyright it. Now, so I have copyright, but the way they did it was that they copyrighted 3 of my posts with that slogan in it. And they said that would, if it ever goes to, the slogan is just so funny, okay? If that was ever used by someone else, like they would start using it as a slogan, that would prove that I had used it first. You know, that I was the original, the copyright office of me. My question is the following now. As the persona of Bohemian Babushka, all right, do I need to trademark that character, that persona, and if so, how does that go around since it's not a real person sort of thing?
Your first question about the phrase that you said you copyrighted three blog entries essentially that had that phrase in it, I think they've got that backwards for you. You can, I mean, assuming that no one else owns rights in it, you can and should trademark that. Copyright provides you an entirely different set of protections. Copyright basically says, if I write a novel, okay, I write a novel about a mad captain who wants to go out and kill this big white whale, and it's called Moby Dick, okay? I own the words in that book. You cannot write that same story the same way using the same words I can. But you know what? You can write essentially the exact same story so long as you use your own words. So copyright protects specific words used in a specific context. It doesn't protect your business identity.
For example,
trademark does.
The movie Frozen is a retelling of the story The Snow Queen. So, and that's kind of how you see the same, or Cinderella. You know, we saw the animated, then we see the live action. It's because you can't copyright a princess with ugly stepsisters that, you know.
But not to get into.
That's so common.
The copyright office told me that I did it first, and I was the first one to
there is value.
one could use that exact, those words, the way I wrote it, and they couldn't use it that exactly.
Generally speaking, you don't own copyrights in very short words or phrases. You own copyrights in the expression of a work. What benefit?
The blog post that you copyrighted.
Yeah, what benefit that can give you is, and not to get into too many technicalities here, but you can register a trademark with the U.S. government. You get a federal trademark registration, but you can develop trademark rights that are called common law trademark rights, which is where you are using the mark and it becomes recognized without being registered. In order to establish common law trademark rights, one of the things you're going to have to establish is I used it first. So that copyright registration you have might help you on that common law trademark issue, but at the end of the day, you'd be much better off with the registration of that trademark.
And we'll be available at our exhibit if you want to do that.
And
No, but
the same with
if you want to talk
Bohemian-
afterwards,
yeah,
we can
and
give
the
you a
same with
little more.
Bohemian Babushka. You may already have some rights because you've sort of created a name for yourself in whatever, in that area. But without trademark protection, there's no real notice to provide you national protection.
Trademark character.
Well, you can in a sense.
Yeah.
I mean, you can trademark. No, but think about the Michelin Man who sells tires. You can trademark the image of that character as someone who promotes Michelin tires. You can't trademark him in the sense that.
Not in air, not just general, abstractly Bohemian Babushka, but in the context and in the manner in which you are using that persona.
It is a very, very confusing area because you can, in fact, sort of trademark, like the character of Tarzan. You can copyright that character by creating a specific enough character and using it multiple times. But again, the protection you're getting there is a protection, is a right that's hard to prove. You're better, trademark with the registration is easy to prove. And so you're kind of creating a more difficult task for yourself down the road. But we can talk with you a little bit afterwards and maybe give you some more specifics if you'd like.
Give us an example of a common law trademark that became defendable.
You know what? These examples repeat themselves throughout the day. It's the small business owner who, you know, comes up with a product and he's using it. I'm losing. I wish I could remember. It's a mechanism to keep your ski gloves on, and I forget what it's called. But it started with just some guy who lives here in Miami, and he created these things back in the 70s to keep your ski gloves on when you're skiing, so they don't fall off when you take your gloves off. Yeah, I forget what they're called. It's driving me crazy. But in any event, for 20 years, all he did was sell them to his buddies in Miami. But he built enough, and then eventually trademarked it and patented it and did everything else. But as long as you've created a product, it's unique, you're using it, you're gonna have superior rights to other people that extend to the geographic area that you're exploiting those rights in. That's what the limitation of common law trademark is. If you federally register that, or patent it, if it's something like that, some sort of invention, then you have national rights, and that's the big push.
Unfortunately, we have a few more questions, but we are out of time. And but please, you're welcome to meet with us in the hallway, and we'll try to continue the conversation. A round of applause, please. Thank our panel for their.
And if you want to jot down our phone numbers, you know, you can reach us even after if you just wanted to ask a question or take our. Yep.
Yes.
It's also in the brochures that are on.
We have a little
around.
booth out front too.
Thank you all very much.